Good day, friends, family. It's been a minute since I've been on here, and because I've been into a lot of stuff. The Telegram channel, I'm back in control of that. But first, before I get started, today is the 19th of September of 2025. This is the only YouTube channel of mine. Every other channel out there claiming to be me is not me. They're scammers. Like I was saying at the beginning here, I've got the Telegram channel back up, and I'm controlling it. It was crazy mismanaged, and I got in there and realized that no one was being added, and scammers weren't being booted out. So I've been doing that for the last week, getting rid of people that I've gone way back into the into the months. And I also have new administrators, a couple of the old administrators. One's going to be returning. She bailed out on account of the other administrator, and now she's back looking over it. And also Lavely is an administrator in there now. He goes by the Prophet. Feel free to contact him through that Telegram, especially if you have questions about legal issues or the HABE. He was very instrumental in writing the HABE. He's quite versed in the habeas corpus. Not to mention, he knows conditional acceptance by the back of his hand. And Joe Listrica, he is a guy who I've been in contact with. He's on TikTok. He gives a lot of great advice. Him and Bree both, they work together a lot of the time. They'll work together on projects, and he does a lot of things, but he also is in the revocation of election. You guys have heard me talk about taxes and how they're gifts and everything like that. Well, this guy has a process that's exited many people out of the tax scheme, or scam, I should say. Well, it's not really a scam, because you should know. You should know that taxes are a contribution imposed, and that you don't have to pay them, man. They're gifts. So the last video I made was about the take judicial notice. Judicial notice, my camera keeps falling down here for some reason. Judicial notice, you file it into the case. One guy had asked a question. I responded to it just recently about it. How do you do it? Well, as soon as the case opens up, you can make a motion to take judicial notice. And I'm not going to go over it in detail, because I did in the last video. If you want to learn about it, go back and watch the last video. But here's what it looks like. Okay, you just draft it up and submit it. If you have to, take it in there and submit it by hand. I would send it certified mail return receipt and do it that way. And if you'll notice here, the case number is right here. So when they get this, they're going to file it and put it into the case, and then they're going to stamp it up here and give you a copy, or should give you a copy. And in here we made certain points. For instance, the very first one, the court must take judicial notice of the Constitution of the United States and the Constitution of the State of Tennessee with all articles and amendments. 2, the court must take judicial notice of the conditional acceptance in the trial record. Tennessee said that we didn't have the legal basis to do what we did when we did the UCC1 filings. And then they put the actual contract in the case and withheld it. That's withholding exculpatory evidence. 3, all officers of the court must file their respective verification constitutional oaths of office into the court record and must adhere to their oaths of office in order to receive qualified immunity. A lot of you are familiar with qualified immunity. The court must recognize that the judgment sheets were never signed nor stamp filed by the clerk of the court, and therefore they are void in accordance with Rule 60.02 of the Tennessee Rule of Civil Procedures, Rule 60, relief from judgment or orders. Okay, and there's a little bit more to that, but I'm not getting into it. We had them notice Brady versus Maryland, Kawana Aku and Polly Blank, Strickland in Washington, Tommy Newley versus the state of Tennessee Supreme Court. It all has to do with due process. 9, the court shall recognize that we are sovereign in accordance with the Constitution of the State of Tennessee, Article 1, Section 1. At the very beginning, I said the court must take judicial notice of the Constitution of the United States and the Constitution of the State of Tennessee with all articles and amendments, okay? So they take notice of that. So we say at 9, the court shall recognize that we are sovereign in accordance with the Constitution, Article 1, Section 2, and then Section 31, Article 1, Section 31, that says the people have the right to exercise sovereignty and the right of soil. That's why you're in an admiralty court. It's the admiralty's court is commerce, and it's the court of water. And then we added some, well, let me see here. 10, if any fundamental right is denied, the person has not been tried by due process of law and the proceedings are null and void. Okay, and then we put on here 11, the court must recognize that in 1969, the Supreme Court of the United States ruled the ability to place a lien upon a man's property, such as to temporarily deprive him of its beneficial use without any judicial determination of probable cause, dates back not only to medieval England, but also to Roman times. That's Snydash versus Family Finance Corporation. It is right here between my fingers. Okay? That's a case law that says you can lien anybody and don't need any reason to do it. Well, you should, but there's no judicial determination. So there is no such thing as these guys filed UCC1s without legal basis. You don't need legal basis. Okay, so we sent that in, and I talked about that in the last video. If you want to go back and see more detail about what it was I actually did, that last video explains the motion to take judicial notice. You do that as soon as the case starts. As soon as you have a case number, create one of these. Because they're not going to recognize the Constitution. A lot of people have heard this. You go into court and the judge says, you don't say another word about the Constitution, or the Constitution doesn't apply here. That's what Blackburn said to me. It doesn't apply here. Why? Because you haven't had them notice it. Judge, I want to see your oath of office. I don't have to show you shit. Put it in a judicial notice and they will. They'll notice it. And if you don't think that they will, They will. See the stamp right up here? Right? This is the response from the appeals court, the Middle Division, Court of Criminal Appeals, Middle Division. And it says regarding M2025-00559-CCA-R3-PC. Christopher Allen Hauser, James Michael Usinger in the state of Tennessee. See, in this one here, folks, I'm trying to make sure I don't have my address on here. I filed it, Christopher Allen Hauser, sovereign et al. Petitioner, okay? So, what does that mean? This is take judicial notice, and they agreed that I'm sovereign, and they even respond not saying that. They haven't even changed the name of the case. Okay? See there? They got it in all caps. Well, when I go to argue it, I'm going to say everything you've sent in all caps, and, you know, without saying the way I filed it. They told me, I called and I said, why are you changing the name of my filing? You're not supposed to be doing that. Oh, well, you don't get to determine what the title of the case is. Well, that's because they don't want to. They want to think that they're so used to doing the trust, you know, listening to appeals from the trust, that they're going to tell you not. And this is a response to the motion to take judicial notice, okay? This is the response. Notice, motion to take judicial notice. It says it right here. Motion to take judicial notice. Attached is the cover letter. Please find the reference notice issued in the above case. If you have any questions, please feel free to contact our office at the number provided. Now, and they sent it to me, Michael, Ron, and Benjamin Ball. I don't even know who that is. But they CC'd it to him. And it says that the appeals court office has entered the above action. See that? The appeals court. The appeals court clerk. They've entered it. They've entered it into the case. But what does that mean when they enter it into the case? It means they acknowledge it. I don't know why this thing keeps sliding down on me here, man. In another letter, I was looking for it earlier and I couldn't find it. But they actually say that, let me see if I can do this right here. Hang on a second. All right, had to do a little work on this this mount here I got. It's not wanting to work. It's wanting to hold the phone up. All right, this should probably work, I think. We'll see. Anyway, okay, back to the deal. So in this, when they sent this letter, I don't know if they filed it on the website, because I'm doing this all electronically now, doing these electronic filings. So that in the letter they sent, they said that they acknowledge it, they've accepted it, they filed it. So, but we were unsure if they were going to put their oaths of office in there. So we found their oaths of office, and we're going to attach their oaths of office, because we haven't heard anything back since we did all this stuff. There's been no response to our clarification motion that we filed, and a couple other things we filed. We haven't heard anything back, and usually they'll respond to anything that we do. When we do something there, they got to do something too. So, but when we put the motion in to take judicial notice, we got correspondence back from them saying that they've entered it into the case, and they accepted the motion to take judicial notice. Actually, they have to. They can't say, well, we're not going to take it. They actually have to. There's plenty of law out there that says they have to take it. And they don't have to be facts. They just naturally assume that they're facts. So, and they said that even though we did the motion and they have accepted it, we won't be able to argue those points in the oral argument in the appeals court. We won't be able to go in and say, okay, do you have your oath of office in there? And do you have, or let's talk about the conditional acceptance, the actual contract that we had. All those things that I mentioned, those 11 points that are in the motion to take judicial notice, they were basically saying we can't talk about them in oral argument because they're not in the brief. So I talked to Ron and I said, look, man, this is what they're saying. I said, a couple of things is happening. Either they think we're dumb. They think we're fools. And we're not going to catch on to it, like we didn't learn enough to deal with their system. And so they're thinking, well, we'll accept it because we have to, but we'll tell them they can't talk about it because it's not in their brief. So it's either that or they're saying, look, these guys are pretty smart, man. And we really want to talk about these things that they're mentioning in here. We'd like to be able to hear his argument on this. Let's set some precedents, And so we're going to just tell them in the letter that they can't talk about it in the oral brief because it's not in the oral argument because it's not in the brief. So I told Ron, I said, we just need to do an amendment. Okay. I covered up our addresses down here because TikTok or YouTube will take videos down if there's an address on there, even if it's your own. So those are covered up. This is the amendment. Okay. In the original amendment, in the original brief, we filed our points. There's like 5 of them. So there was 5 of them in here, and there's like 18 pages to this, y'all. I'm not gonna get into much detail about it, but the issues presented for review: whether the post-conviction court erred when calculating the deadline when utilizing Tennessee Code Rule of Civil Procedure, Rule 6.05, that adds 3 days to the time limit due to being sent through the mail, and whether the post-conviction court altered the date that it received the post-conviction complaint in order to make the complaint late by 1 day. Whether the post-conviction court had the authority to sever the defendants, Cromwell, Cooper, from the other 3 since severance was denied in pretrial and carried throughout the trial. Motions for new trial, direct appeal by permission to the Supreme Court of Tennessee. Third issue: whether the post-conviction judge erred to respond to the post-conviction petition within the time limit set forth in Tennessee Code Annotated 40-30-106A by rendering a decision 9 months after it was required, yet stated our post-conviction claim was allegedly filed 1 day late under suspicious circumstances. Okay, these are the stuff from the original amendment we had to, or the original brief. Then we amended it, so we still have to put this is the brief that's going to overlie the original brief. Whether the post-conviction court erred when they failed to allow the post-conviction complaint filed by Christopher Hauser to be considered as an amendment to Lee Cromwell post-conviction complaint that was timely filed according to the order of dismissal that Judge Blackburn had failed to address within 30 days required. We're saying, you can't sever us. And Blackburn had 30 days to respond to our post-conviction relief filing, and she waited 9 months. But see, then she turned around in the denial for it and said that Lee Cromwell had filed a petition for post-conviction relief, and that it was filed timely, and she just hadn't a chance to look at it either. So she admits she's 9 months late on 2 post-conviction relief filings, but it was timely, so it should have been considered. Even if you don't want to address it and say, okay, it was a day late. Let's say that. But we were never severed, so ours should have been an amendment to Lee Cromwell's. That's what we're saying in that point. Whether Judge Blackburn erred by overstepping her authority when she said in open court that the jury would not see the contract when asked by the defense counsel. Okay, that's where the amendment issues start. We were only allowed to talk about those 5 issues because these other issues that we mentioned and take judicial notice weren't in the original brief. So we've added them to this by an amendment. So here we go. This is the first one that was added to the brief. Whether Judge Blackburn erred by overstepping her authority when she said in open court that the jury would not see the contracts when asked by the defense counsel. When you read the transcripts, page 603 through 605, that's what we're referring to. We're referring to this conversation that they had at the end of the trial without the jury, and in there listening to it. And one of the defense, or the alleged defense attorneys, said that, hey, can we talk about the contract that's in the record? And the contract, y'all, is a conditional acceptance, okay? That's the contract. That's the actual lien. Filing a UCC1 is not filing a lien. The actual liens were sent with the UCC1s to the Treasury, and the Treasury filed the liens. So you're gonna bust somebody out for that. Go get the Secretary of the Treasury. But the defense attorney said no, they're marked ID only, right? ID only. And so the defense attorney asked the judge, so do we get to talk about these or what? She's asking the judge to make a ruling, and the judge in the transcript says absolutely not. Absolutely not. The charges that they brought on us was we filed and we forged unlawful liens based on nothing. There was no without legal basis. When you read Tennessee Code Annotated 39-14-114, it says that to lien a man, depriving him of the beneficial use of his property without legal without legal basis, okay? So the actual law says you can't lien somebody without legal basis. And then the judge, the prosecutor, and the defense attorneys hid the contract. Okay, we're not going to show this to the jury. We don't want them knowing about this, okay? So that was a conversation they had. This is in the amendment. Now we get to argue that when we go into the, look, this is what Blackburn said. Here's the transcripts. Read it for yourself. And see, the thing is what they said we didn't have any legal basis to do. Yet the federal court says it's a provable debt. It's discharged in bankruptcy. My ex-wife discharged $4 million in a bankruptcy. I won in tax court. You guys heard me talk about beating the IRS in tax court with the same concept. Look, the federal courts say that this is a provable debt. How can it be a frivolous filing if it's a provable debt? Oh, well, we agree. And the tax court is a subsidiary of the Treasury, and so is the IRS. So if the tax court and the IRS agree that it's a provable debt, it's not a frivolous filing, then the Treasury agrees. The Treasury is the one that holds the contracts. The Treasury is the one that was supposed to collect the $204 million in lien securities and pay me $132.6 million. Now they agree. Now they agree that this is a provable debt. So the feds are saying this we're legit. You guys are good. You're good to go. But the state of Tennessee is going to have to start backing up. We did have legal basis to do what we did, and you arrested us without a warrant. You arrested us without an indictment. You didn't tell us what the charges were, and you had a trial we weren't allowed to go into. Oh yeah, you're going to freaking get a 1983 put on your ass, state of Tennessee. It's happening. We're just waiting to see how they're going to respond to the oral argument. If it's not favorable and they ain't kissing our asses, offering big freaking settlements and shit like that, we're going straight to a 1983. Not the year, folks. It's a filing. Deprivation of rights under color of law. Whether the trial court erred when they failed to file the judgment sheets, since they are not stamped filed, nor are they signed by the clerk of the court, making them void per Rule 60.102 and the Tennessee Constitution, Article 6, Section 12. Our judgment sheets weren't stamped and signed in the Constitution of the state of Tennessee, which they recognized. They put it in it's in there. It's in the case now. You recognize this. Whether the trial court erred when they hid exculpatory evidence from the trial jury, creating a Brady violation. And that's what it is. Withholding exculpatory evidence is a Brady violation. After the trial was over, one of the witnesses, Melissa Hauser, that's my ex-wife, who stated that she had no contract with us during the trial, filed bankruptcy, which she filed the contract with the bankruptcy court to prove she had a debt. She got up there and said, I don't have a debt. I don't have a debt with my ex-husband. I don't owe him $4 million. Under oath. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yeah, I do. Now let me lie about this freaking debt, and then let me go file it 8 months later in bankruptcy. And the federal courts in Greenville, Tennessee, allowed it to be scheduled, which goes against the if it's a fraudulent debt, it can't be filed. Only provable debts can be discharged. That's 2 United States codes that they failed at. If in fact she was telling the truth, she wasn't. Neither was old Tim Birdshit, the senator, the Republicans representative from the state of Tennessee. The difference between my ex-wife and all the other public officials that got up there and swore under oath that they didn't owe us any debt, committed perjury, aggravated perjury, and most of them, to have the UCC1 removed, they had to sign an affidavit saying they didn't owe us any money. That's 2 charges. My ex couldn't do it because she wasn't a public official. So that's that. I mean, that's just page 5. There's 17 pages of this, and it breaks it down. It breaks our case down, our argument down rather well. And in the conclusion, we believe that the post-conviction judge erred in dismissing our petition for post-conviction relief for several factors. The first factor is that the fact that we believe that we filed our petition in a timely manner and due to circumstances beyond our control, it was determined to be late by 1 day. It's clear by the evidence that the dates had been altered, which is again beyond our control. Secondly, we disagree with the judge's authority to sever the defendants due to her own denial of severance during the pretrial motions. She denied this severance in the pretrial motions. Thirdly, we believe under equitable standard, if she filed her response in an untimely manner, how can we as laypersons be held to a higher standard when done in good faith? And finally, not only did she fail to follow Tennessee Code annotated in that she severed the defendants going against her own ruling, but going against the state's requirement to respond within 30 days. Next, it is clear that SCOTUS has already ruled that we can put liens on someone without judicial determination. We did have legal basis in the form of common law contracts, which are hidden from the jury, along with affidavits from witnesses that perjured their own testimony in the trial. Further, we have been conspired against from the beginning and all the way through the whole action. We pray to the Almighty Father, Elohim, that this court, even though they have heard this case before, that this time, with the truth being told, that they can come to a right ruling and overturn this bogus action. Finally, the simple fact that truth is that we did have legal basis for the liens that were filed with the United States Treasury, not in the state of Tennessee. When you recognize that fact and truth, the rest is mute, and you must overturn this case on the fact alone. We have had legal basis, and in that truth, you should recognize that this has been a conspiracy from the start. The question there becomes, are you a part of the conspiracy, or are you truly judges of truth and justice? Respectfully submitted, Christopher-Allen Kohlenhauser, beneficiary, that's what's going down. And we attached the 5 oaths of office. We attached the discharges, my ex-wife's bankruptcy discharges, and the whole case file. There is 23 PDF files. Some of them are transcripts, and some of them are the judgment sheets that aren't signed. There's not a single judgment sheet signed. Out of all 5 of us, they didn't file a single one, which means they're void. In all actuality, I've never been convicted or done time in prison, which means I've been in prison unlawfully. We all have. Gary's still there. 8 years now. That old guy's been locked up. refusing parole. He's a better freaking man than I am. He's sticking to his guns, man. And when this is all over and done with, Gary had a case that went in front of it was in tax court in 1989, where he asked the tax court, if there were two different entities, and they actually said yeah. In this case, they actually said yeah, that two people are being, or two entities are being in this court, that it's you and it's also your trust. I found that here a while back. One of my guys gave it to me and said, hey man, check this out. This is Gary from 1989. So Gary's been doing this thing for a long time. And actually, it was surprising to read. And the article was photocopied out of a book that, what was his name? I talked to him right before he died. One of these big guys in the sovereign movement thing. If I hadn't tried to think about it, I would have remembered it. But anyway, it was from one of his books. The dude actually wrote about Gary's case in one of the chapters of his books. So yeah, man, it's crazy where this is going. There's going to be there's a lot of stuff in the case getting filed in the whole thing, because see, when Division 3 was notified that we filed an appeal, they sent a court record to the appeals court, not the court record. See, so they're hiding it. They're hiding it. They're hiding the contracts too. When this all comes out, it's not gonna go well. It's not gonna go well for the people that did us the way they did. But anyway, glad I could share this with y'all. Remember that this is the only YouTube channel I have. That's it. Report those other folks. You know, I'm not much for snitching, but these people are out here scamming. And guess who's catching the freaking flack from it? Me. Because they think, I'm out here doing this grant shit. And I've said it time and time again, you cannot create a grant from your trust. And also the Supreme Court case, the ruling, the Supreme Court ruling. I don't think I have the number around here, but the Supreme Court ruling, the one that's on YouTube channel, for that case right there, they say in there that UCC1 has value. They took a document that had no value and made a negotiable instrument out of it. I've helped a half a dozen folks with their foreclosures, and including myself, my father's estate, and gotten titles. Hear these people thinking, I'm about to lose my house and shit. And they go, oh no, we don't want nothing to do with what you're talking about, dude. Here's your title. Get out of our court. So, and it's not that UCC1 doesn't just apply to the foreclosures. It's for all debt. If you bought a car and the finance company financed it, more than likely, they did a UCC1. The UCC1 can actually pay for the car. If you've been paying on it for a while, get them to take the UCC1 to the Federal Reserve Bank and cash it in. pay off the debt. It's quicker than trying to use a 1099-A to get anything paid off, any debts paid off. Have a blessed day.